Oh, 6:30, huh?
What we talked about, remember?
I know. He wanted to be 6:30, right?
Yes.
And then
That's just
we
gonna
talked
be-
about it again last month. But we never
Right.
made it official.
You gotta mute the YouTube.
All right, how do I do that?
Just on the left side of the video window,
Down on the bottom.
down on the bottom.
Next one over to the right. Click on that, no, click on the.
Where the
bottom.
little
The little
speaker is.
next to where it says live.
Go the other way.
Pause,
So,
play,
right
live.
there.
You.
There you go. And that one's gonna be on a delay, so it's a little better to just have the Zoom one.
No
up.
one.
All right. Well, let's open up the meeting February 20th, the zoning board of appeals. I appreciate everybody coming out in this weather. In favor. Pledge allegiance to the flag, United States of America. To the republic for which it stands, one nation, under God, indivisible, liberty, justice for all. Apologize for the delay. We just wanted to give everybody an opportunity that wanted to make it to the meeting due to the weather to get here. So we have two applicants for this evening's meeting. Let's do roll call real quick.
You want to go through everyone?
Yeah, go through everybody. We'll just make note if somebody ends up coming in late
Chairman Clay,
here.
member Sam,
Here.
member Charlie,
Here,
and then we have Mary Lou.
And right now,
We're waiting for Ken.
Ken
to get-
Stevens and Harley Davis is absent.
Yes.
Right. Our first application is Michael Bazinet. If you want to come on up, man, have a seat with us at the end of the table. This is application 2024-07. The applicant is Michael Bazinet. He's on 20 Melody Lane, section block and lot number 67.2-39.100. The applicant seeking proposing a building of 24 by 40 foot gambrel style structure to be used as a bakery slash cafe. It's a new application. Got anything you can add? You got anything new that you wanted to present, Mike?
I watched the last meeting from the 16th,
Sure.
and you guys brought it up, but I didn't gather any specific questions that you had out of there. So let me just, I'll give you a little more detail on that. The structure I put in there is the maximum size that it would be. We'll see how much money I end up with. It'll be either that or smaller than that. There was one mention of wetlands in the last meeting. And that I have on the application as no, based on the DEC wetlands mapper site.
Okay.
I do have a picture that pulled up, or we can pull it up live if you needed to.
Okay.
That was the only things that I really recognized that maybe were in question.
The only reason we didn't open up the application is because we wanted you to have the opportunity to be here. That
Yep.
way, if the board members had any questions, we could ask you and you could provide the information rather than hearsay. Application here. Everybody, Charlie, did you get a chance to look at this application?
yeah, I did a little bit. The one question we had. Where the driveway was coming off of, and you had it for 6-something Cherrytown Road? There is
Oh.
6-something Cherrytown Road, or 9,
Yeah,
9.
Yeah, it was, I
924.
went by the old mailbox number when I was growing up. And I wasn't sure if that was right, and I couldn't find any of it, so it was 923, R2 box 923. Which the mail still comes to occasionally, I don't know how they know that. But that's why I put that down, if there's a different number that I should be using.
Well, yeah, because there's 923 is. Way up the other end,
Yeah, it's not even
I don't even,
remotely
I don't
close
even
to the
think
new
there is one
box
on
numbers.
Cherrytown Road anymore.
And,
Oh, I mean, my address is 20 Melody Lane, I don't know of another address.
And the driveway's coming off Melody Lane then?
The driveway is Melody Lane.
No, okay. yeah,
The,
but
the
I-
approach for the building, the proposed building, would be coming off Melody
Off
Lane.
Melody Lane, yeah.
that's how the building inspector.
Mhm.
called it, 20 Melody Lane.
Sam, did you get a chance to look at it?
Yeah, so you're looking to do a bakery, code enforcement office said, like, reviewed it against the new zoning law. And I guess he's thinking it's either like a restaurant or a retail service establishment. And both of those just aren't allowed in that zone. So it's A3. It's not allowed in A3. So we're not even talking about like an area variance where,
It's a use
No,
variance.
it's be a
It
use
would be a
variance,
use
strictly a
variance.
use variance.
and that's, very high bar. I don't think this town
It's a very, very. high
zoning
bar.
board has ever
It's
issued a use variance.
it's a
We
one-off
have,
for
but it's been a
us,
long time.
Yeah,
especially with anybody currently on this board.
right.
Have you had an opportunity to review all the necessary items that have to be produced for a special use variance? Have you been,
A use variance, not a.
not special, use, excuse me, I misspoke, a use variance, not special use, there is a difference.
No,
Okay, I think one thing, the major thing to be aware of is the financial need has to be proven by you. That it can't be accomplished someplace else, and that it's gonna have a negative impact financially for you. Okay. Getting off of that topic real quick, on your, the short environmental assessment form. Section 9, if we look at that, it says, does the proposed action meet or exceed the state energy code requirements? You check yes. Then on here, it says, if the proposed actions will exceed requirements, describe design features and technologies. What do you have for technologies, features that are going to exceed the guidelines and energy code for energy code? Because there's nothing on the list. There's nothing listed.
it meets or exceeds. And there would be a building inspection that has to meet a certain energy code, right?
I think,
I wouldn't build it below the energy standards for insulation, for, heating and that.
so there's nothing that's going to exceed that then. There's nothing
Uh,
extra. You're not looking to enhance.
there wouldn't, not in this area, because like, for instance, solar would be prohibitively expensive in this area. I would have to take down 5 acres of trees to get any sort of line of sight there, so that wouldn't be. I'm not sure what other,
Melody Lane, is that a private or a town? Is it
Yeah.
private?
that came about when they were updating, I think, 911 maps,
Okay.
and we were asked to choose a name for the driveway. Other than that, before that, it didn't have a name.
Right.
And it was the priest down in Ellenville at the time, Father Hickey, that suggested we call it Melody Lane. My brothers were both musicians, so.
And off of Melody Lane, how many other homes share that road? And is there easement on the property that it goes through?
What do you mean by there's
Right away. Is there a right of way documented
That-
in there for Melody Lane to go across that property?
that driveway continues up with properties on either side of it. My property is on both sides of the road and up on to the right hand side. The next property up on the same right hand side is my brother's, and the next property all the way at the end is my mother. Going up the driveway on the left is not a family member, and they have right of way to use the driveway.
But is it documented though in the property? Because the property, although it's one parcel, it's not two separate parcels that are divided by that driveway or
Yeah,
Melville Lane.
yeah. I believe that information was updated when the property was subdivided about, let's say, 6 years ago or so.
Okay.
That, yeah, there was something in there documented. I don't have that information, but I would have to go find it.
What do you guys
So-
do?
I mean, I was just thinking about what you brought up, Clayton, about the standards that we have to look at for a use variance,
Mhm.
which ours is very high. So there are reasonable return, which is that you have no other way of the use of the property being like financially possible without being able to do this. And I think like just from what you've already said, right, it's a family property, you're already living there. It's a residentially zoned property that's like existing. So to make a claim that, I mean, what the law says is the applicant cannot realize a reasonable return provided that lack of return is substantially demonstrated by competent financial evidence. So that'd be like if you owned a property or bought a property that was for a commercial use, but there was maybe like some specific commercial activity that you wanted to do. That like there was nothing else you could do on the property except that use. And then they were saying you can't do that use because of the zoning law, right? That would be. I mean, I can't come up with a good article off the cup, but.
And where are you in that book?
Oh,
'Cause I-
page 12 on the first section.
Okay.
So there's that. And then there's like unique circumstances in the second test. So I think the first test is already just gonna be. Like a pretty high bar.
And on that first test, right here,
Clear.
I'll give you this one, you're done.
Yeah.
Everything here in this green column on three or four pages is
Section,
what
Is
is
allowed.
the different uses of what's allowed and what's not allowed
yeah, section.
in your
appendix.
zone.
Sure.
You'd have to show us that you couldn't do any of these things and get a reasonable return on your property.
Including living.
And you need financial evidence. You have to bring financial evidence as to why that
It's-
won't work. So just so you know, it's
Okay.
a, as Sam said, a very high bar.
It is, that's why nobody ever does this, because it's so
It's difficult.
economically taxing on people that are trying to do this, but.
But Sam, did you want to go over?
Oh, I mean, the
You're
other
going-
ones are, you have to have unique circumstances, so the property has to be somehow uniquely different than. Kind of every other property that has that same zoning. So kind of like, oh, the. Town board missed something essential about this property when they were
Like being on a mountain, it needs to be a ski slope and there's no other mountains in the town.
or something.
Or, you know, if when they changed the zoning, your property happened to be amongst a kind of retail section
Right.
with bakeries and
Yeah.
an ag way or, you know, whatever. And then they changed the zoning. And then you could argue, this neighborhood is a retail neighborhood. Something like that.
Do you feel like you can get through those hurdles?
No.
I mean, okay,
So what's gonna happen, well, what could possibly happen in the next few months is. Or let me just say this month. Is that I no longer have a job in Fishkill. I foresaw this potentially coming as of last year. And thought I could make. Some go at something that I wouldn't have to put out insane amounts of money. To pay somebody else for use of their property, right? Yeah. So one of the things that I did look into years ago was where Mill and Main is now down in Cohasset. And that. Right off the bat required $48,000 in back taxes. So that would be before you're doing anything at $50,000.
yeah, that's,
It took me 2 weeks to hunt down somebody to even talk to about that, and they were a company in Florida that said, just make us an offer, we just want this off our books, and it was, you couldn't get in to see it, because nobody would allow you in, because the Florida company wouldn't send somebody up, and the town wouldn't allow you to go in.
right.
So anyway, that was off the table. Then a couple doors down where that church is now, I looked into that. And they said, no, we're gonna go with the church instead, so that was off the table. And then it went to the back burner because other things happened at work and I ended up, moving in different positions there, so. Now I'm revisiting that because of the instability in semiconductors again, that's where I work down in Fishkill in semiconductors. I'm driving like an hour there every day. And there is a huge downturn right now in the electric vehicle and supporting market for automation, for Internet of Things, basically, a big downturn in that. So they intend on the rumor this week, don't go making any stock purchases based on this. 10% possible cuts across the, company. So I'm a little late to the game on trying to get this, but I wanted to try and use the assets that I have to make some sort of use. Maybe there is something else on this list. Baking is like a hobby of mine,
Sure thing.
and something I can do. And I don't know if it would make a difference if nobody else came to this bakery, if I just baked goods and took them somewhere
It'll
else. to sell.
still be.
It's the
Well,
same
there's
thing.
home
So,
occupation.
well, I'm thinking home occupation. If he doesn't have other people coming there, delivery trucks,
Cause I know other people do
It's
that.
still, I
like
think,
dump
gonna
sourdough.
fall under special use.
no,
What
it
about
could fall
that?
under home occupation, which
Okay,
is a whole
what
separate area.
about still meeting some of
What-
these requirements?
It's different requirements for home occupation. What you'd have to do is whatever changes you want to make, you have to go back to the building department, talk to Mr. Davis, and he'll make a determination. Either he'll say, no, you still need to go get that variance, or he'll say, you can do it under this section of the code, which may still require you to go to the planning board, but not necessarily to the
It's-
zoning.
Right,
board.
it sounds like you'd be in a situation where instead of needing a variance, it'd be the equivalent of you just putting up a barn on that piece of property, as long as it fell within the guidelines and the setbacks properly, correct?
It depends on,
And then-
on
and
what
then-
types of home occupation. Let Jerry discuss those
Yeah.
things.
Yeah, and not, you
That's
have to
his
go through
area.
some sort of health inspection also, but.
And I'm sure, I think Courtney, if he just wanted to talk to Jerry about what can I do on this property,
Yeah.
Jerry would
I
be
would
willing to
sug-
do that, I
would
would
suggest
think.
looking at our zoning code, it's under this home occupation, there's class 1, 2, and 3, and if you think that one of those is suitable for what you're trying to do, then you could always propose the idea back to Jerry.
Okay, is that accessible on the
Oh, yeah.
site?
Yeah, yes.
So you go to our website, you go under it's the E-code 360, and then you have to go on the left-hand side, you'll see the new laws. And they're under
And-
those.
For home occupations, depending on the class, there's some need site plan review. Some are just permitted with a site plan. And some you need a special use permit. I'll give you this,
Okay,
everything that's in green, there's little codes here, and it tells you how the different uses fit into your zone. You
great.
pass that down, Ken.
And one option is a helicopter pad.
This helicopter pad.
Yeah, that's allowed with the special use permit.
Not in this area, they'd have to come down through a corridor.
There's a lot of knuckleheads up there.
Low impact healthcare practice.
I just need to get a doctor.
Raise chickens.
A recreational club.
But while we're discussing it, I mean, I would also think that they're gonna ask at some point, regardless of what direction you go, for a little more detail in regards to that piece of property. So I prepared myself for that. That's advice. I would recommend finding out whether or not there's a right of way through there for those houses that exist that could be potentially impacted.
And then they have to have a road maintenance agreement.
Yeah, and if there's.
There's no right of way through where the structure would go. It is just the driveway.
Right, but access could be a
Yeah,
concern
that's gonna be a concern. It's absolutely gonna
if
raise
it's
it.
a private.
To me,
Right.
having reviewed it and looked at everything, I would think that would be the biggest hurdle outside of the use variance that you would see.
So, specifically, what do you think that is the issue?
I think you're gonna have to have a right of way established on the deed, survey done, and agreements by all the people that utilize that Melody Lane. That if you're gonna open up any form of business or use for your home, that it be addressed,
And
or
if
any
you-
addition to the
And
buffer.
it may be in place, we don't know.
Right,
That-
I'm
That
just,
could exist, but
There
you,
is a,
and it could be, especially if there was a subdivision, but it may only be a residential.
it may not be a subdivision, which,
Right, he had said that his family subdivided a few.
the,
years
yeah,
ago,
subdivided.
subdivided the property, it's not, I think one more house would make it a subdivision.
Okay,
I think that's,
Okay.
that's what I remember.
Three or more is considered subdivision.
So it could be a dry, it could have
but
been
when
a
it was
driveway. at the
done,
time.
when it
Yeah.
was done, you know, that's kind of semantics.
But-
He could have had, 20 homes on there before zoning code, we don't
Yeah,
know.
we know some roads like that.
Yeah,
But when you have thought this through and you have an idea of what you want to do, get a good drawing plan and bring it to Mr. Davis and
Yeah.
discuss it with him.
but I think,
And because he'll know for whatever it is, what you need to do.
so at this point, how do you want to proceed with this application?
Well, I'm gonna probably, I mean, it sounds like I'll never get above this
It
financial.
it would be very
hardship hurdle.
difficult.
Yeah.
Do you want to withdraw your application?
You submit with
And then
And when
So
you know
the
what you want to
Davis,
talk to Mr. Davis.
the home occupation is a separate thing.
Yeah.
Okay.
Send me an email tomorrow and we can set up an
Yeah,
appointment and we
okay.
can get you on the books and we can go over a couple ideas that you have and we'll go from there. We'll figure something out for you.
All right, cool.
anybody else have any concerns, questions?
If you can't do something there, there is a few places out there for rent, maybe that's cheap, I'm not sure. I know
Yeah,
the old casino is for rent now, right?
that's
have no
a
idea
dead
what you want.
location,
That's right on 209.
yeah.
Or
That's,
not even coming down the mountain.
Yeah. That would
Don't
be a-
give up,
would-
man.
And
Would
it's
be a
huge.
good location.
That
if
would
you
be a
could
good
afford the
location
rent.
on weekends for sure.
And especially if you're gonna do something where it doesn't require you to have
Yeah,
open
because
space for eating and stuff like that, man.
Yeah,
Hey, maybe it'll fit the bill for you.
Yeah.
like Cohen
Wow.
Bakery in Elva,
Charlie, you're right.
they're open for lunch and breakfast,
yeah.
you know.
that place,
What's your specialty item? What do you make best?
Oh, I've been working on laminated brioche a lot. Today I made some savory
Thanks,
ones.
Mary Lou.
I know, I'm sorry, I know, we get to eat dinner.
Maybe next time I'll bring some.
Thank you for your time, man.
Apologies for being late.
Yeah,
Hopefully
no,
something-
don't apologize.
hopefully
The
you'll be able
weather's
to
not
figure
nice out
something
there.
out, Mr.
Is it still snowing?
Website ends it at 6:30, so I'll
Davis.
talk to Aaron about that later.
Well, we'll have to address that.
Maybe that
I mean,
explains why.
but now you can
everybody's
find
doing
it on the website.
So with the board with regards to this application, it sounds like it's gonna be withdrawn temporarily, be re-reviewed through the CEO. And we'll see you again. If not, best of
Or
luck with
maybe the
everything.
planning board.
I'll
will.
remember.
Best of luck.
Skip right
I'll
over.
remember pastries next time.
Don't do that.
Now, we can't accept pastries.
I'll get in trouble. No, I'm kidding.
I'll just leave them outside.
Good luck.
All right, thanks a lot.
Take care, good luck.
Next application is going to be RV Associates, Inc. ZBA 2025-01. You want to come on up? Route 209 and Megahunk's Road, it's section block lot number 76.2-5-3.119. The applicant is requesting an appeal / interpretation for a gasoline and diesel filling station.
Would you like to just mention? what-
Yeah. What we have is we have another unique situation where our current attorney has to recuse themselves from this application. So what we're gonna end up having to do is we'll open the application. We just won't have any legal representation right now, which will be addressed before the end of the meeting. Appreciate it, Mary Lou. Appreciate your comment.
Drive carefully.
Yes, you too.
Nice to see you all. They don't have me at every meeting.
Well,
so-
no, anytime you're more than welcome to come.
Well, good.
Yeah.
If you want me, I'm welcome, nice. What if you don't?
No, I mean, rather than you
You
two.
can even come in, and just visit if you want.
Yeah.
I love it.
Be in the,
Exactly.
be in the audience.
All right, everybody have a good night.
Take care, Mary Lou.
See you
Drive
later.
safe out there.
We'll probably talk. We haven't talked this week. you
Yeah,
know?
I'm sure.
You'll probably call me tomorrow.
I'm sure I'll have a question.
Take care.
Take care. So this is another unique one where it seems as though applicant's looking for an appeal based on a decision made by the CEO about language that was originally published in the new zoning codes. Now, that law, the zoning code has been re-voted on by the town board, redlined and corrected. It's my understanding. The law was passed. That's
Well, they have
what I know
a-
to this point.
They have a,
Hearing.
they have a public hearing on
They had it or haven't?
it's
Have it.
scheduled for.
Okay,
next
so
week.
it hasn't
That's
been,
right.
You're paying close attention.
Yes,
so it has not been voted on yet.
no,
Right.
Okay.
correct. It was introduced at a, sorry, I'm.
No, that's okay. That's
Good,
okay.
well,
Yeah, it was
good evening,
introduced-
Nicholas Ward Willis with Keenan Bean for the applicant Gasoline Petroleum.
Thanks. man.
The subject, local law amendment was introduced by the town board. It was workshopped twice, and then they scheduled a public hearing for their February 27th meeting.
Okay.
So the law exists today as it was, when adopted back in November.
Okay. All right, so that's where we're at. Like I stated before, we're skydiving without a parachute right now when it comes to this. We haven't seen something like this before. What can you as the applicant's representative provide for us in regards to what you're seeking here?
Sure.
Please.
Thank you. So what I'm seeking tonight is that this board schedule a public hearing for your March 20th meeting. I think that is the next step. Your law requires you to hold a public hearing. So I would respect to say, even though you don't have counsel, procedurally, that's the next step, and it's appropriate to take that. And we would ask that you do that tonight to schedule a public hearing for the 20th. I trust you would have counsel engaged by then. And then at the meeting on the 20th, if you determine you need to continue it, you can do so. But at least it would allow the process to move along in a timely process. And I make that request just to give you some background on our application, and it's not germane to what's before you, but I think it provides context. Our client submitted an application for a gasoline and convenience store at the corner of 209 and Metacons Road, and made that application in March, appeared before the planning board in March, July, and September. We're expecting to be, we were told there would be a public hearing scheduled at their October meeting. Instead, we were not scheduled for the October meeting. And instead, we learned that the zoning law was changed, and there was never any notification to our client that the zoning law was being changed, despite the planning board and their staff reviewing that. So we were a little blindsided when we were told that, well, it's no longer gasoline and filling stations, no longer a permitted use. If that was the intent, we would have appreciated hearing that from the staff. So that's why I'm sort of trying to move this process along, because we don't think we've had our fair shake before other boards, not this board. So I think it's appropriate to just follow the law, follow the process, and schedule that hearing as the next step. So we received, it was unusual, the planning board chairman asked for a determination from the code enforcement officer as to how our application fit under the law. And that determination was made without consultation with us. No one reached out to us and said, would you like to be heard on this? And the code enforcement officer did not reach out to us. We did say we'd like to be heard. But before we had that opportunity, he submitted his opinion on December 17th, and it's in your materials, basically finding that a gasoline and filling diesel station was not a permitted use in that district, which is correct, but that a convenience store was permitted, and that a gasoline and filling station was not permitted in the aquifer overlay zone. Our property is located in both the B district, and then there's the aquifer overlay protection zone. And we then, upon reviewing the code as amended. Should we continue?
Yeah, go ahead.
Okay, and then reviewing the code as amended, we submitted a revised application on December 17th. As we were now a convenience market and fit that definition. And it's in our materials. I know it's no answer, I won't go for a full application. And then the code enforcement officer issued a second determination on January 22nd, reversed his prior opinion that we were a convenience market, and said that a convenience market couldn't have a gasoline filling station, and we weren't permitted to be located over the aquifer protection zone. So the code has language in it that a convenience market can have a gasoline filling station. There's a mistake because, as you know, it says it can't be permitted and it can't be permitted. Well, it can't be two things, we can only be one, and the law says that when there's a conflict, you have to err on the side of allowing property rights instead of taking them away. And so we believe we are a convenience market and we're allowed to have the petroleum products dispensing. The next question then becomes, is that allowed in an aquifer protection overlay district? So the aquifer protection overlay district in section 140-5.1A2 has a list of some prohibited uses that are not permitted over the aquifer protection district. The permitted use that is relevant to this inquiry states that chemical or petroleum product manufacturing and bulk sales are not permitted. And it then says parenthetical, e.g., meaning example, gasoline filling station. So gasoline filling station is a defined use in your zoning code. It does, as is convenience market. We're not a gasoline filling station, we're a convenience market. And this code doesn't say convenience market is prohibited, it says gasoline filling station, which is a separate use. So we think the code enforcement officer erred for that reason. Convenience market permitted, gasoline filling station not. It also says that what is being prohibited is chemical or petroleum product manufacturing. I think everyone would agree a convenience store and gas station isn't producing or manufacturing gasoline or petroleum. It then says and bulk sales. And in our papers, which I hope you've read, we argue we're not bulk sales. I don't think any reasonable person using the dictionary or common sense would say that gasoline sales are bulk sales. It's a retail sale to individual consumers. We're not having bulk sales of gasoline, and we've gone in depth and that provided you with support for that. The question then becomes, when it gives an example of a gasoline filling station, if we agree it's not a bulk sale, the fact that you provide an example isn't an example of a regulated activity. If they had said, for example, you can't have a dry cleaner, well, everyone would say a dry cleaner is not a bulk sale. That's clearly wrong. Likewise, because they gave a wrong example doesn't mean you can now regulate something because they misspoke. There needs to be clear legislative intent when you're dealing with property rights. So we believe that the interpretation on both the December interpretation and the January are just wrong on the law, and common sense application and reading of your zoning code establishes that. And we provided that in some detail in our letter. And in our letter, we request that you make certain findings in reversing the two determinations. That one, the convenience market with the sale of gasoline is a permitted use in the B zoning district. We say that because your law says you can't be and you can be, and the law says you have to then grant the use rather than restrict it. So we think we're right there. Also, that a convenience market is permitted use in the aquifer protection overlay district. As your code states in the clear English, it doesn't prohibit a convenience market which is a defined use. And it's clear here to look not what people want or what people would like, what people hope it would read, or what words you might want to put in there. But this board, when it's determining appeal, has to read the words that the legislative body chose to use. And the overlay protection district prohibits uses. And when you go for your zoning code, you have defined uses. Convenience market is one of those uses. And those two words do not appear in that section over the aquifer protection overlay district. So that you find that you have to find that a convenient market is a permitted use in the overlay district, which I'll remind you is what the code enforcement officer found in his December determination. He said a convenience store is a permitted use in the aquifer protection overlay district. It was only when we pointed out and made the application that he then determined that we weren't no longer permitted.
What did you point out in the application at that point?
We stated that we were a convenience market. And so the third point is that a convenience market is not a use that sells chemical or petroleum products in bulk. I think that's clear. And then the fifth point is we request a finding that the retail sale of gasoline to individual customers is not the bulk sale of petroleum products. And this is on page 8 of our letter. And then also a finding that reference to an erroneous example, i.e. gasoline, e.g. gasoline filling station of a prohibited activity does not serve to amend the zoning code to thereby convert that erroneous example to an activity that is also prohibited.
Can I ask some questions?
Absolutely.
Yeah,
So I guess the first question I have is what, other than the law changing,
Mhm.
what changed in your application between when the law changed and when it?
yeah, I think it's a comparable application, and
So it looks like, I mean, I looked at it, nothing really changed, right? The original zoning permit application came in, code enforcement says this is a gasoline filling station, you didn't appeal that. Right, so by not appealing that, you basically acknowledge that that categorization was correct.
Well, that's only if there's a determination that's a gasoline and.
Well, there was
filling
under the
station.
old law, right?
I don't know that there was. There was reference to it being sales of gasoline and diesel. I did
You're
not.
saying there wasn't, the language might not have been precise. Okay.
That's correct.
Sure.
And I would also, argue, I'm sorry if I'm, don't mean to.
No, I mean,
interrupt
I
you.
just wanna, we can quibble about, I think we can all agree that there's some drafting errors. Both in the section 140 of the town code and also in the code enforcement officer's
Mhm.
letter. But, you know, we're a citizen board and like, we're not formally a court, right? We have some function. But basically what happened is you applied
Yeah.
under the law that existed prior to November of 2024. Code enforcement office says this is allowed because it's a gasoline filling station. At that time, gasoline filling stations were allowed in the B zoning district. Y'all were happy with that. The application was moving forward through the planning board. Then the law changed. You've got some grievance about notification. I think it's immaterial.
And I said that it was not.
But yeah,
Mhm.
but sure, the law changes, now gasoline filling stations aren't allowed. And you're saying, oops, this isn't a gasoline filling station, it's actually this other use, convenience mart, which also has a drafting error. In its language in the new code, saying that it both can and cannot. That gets resolved in your favor, sure. And now you're saying, because it's a convenience mart, not a gasoline filling station. We can move forward. So then the next question I have is, why can't a parcel or like a project encompass multiple uses? Because that's an implicit claim in what you're saying. You're saying this project couldn't be two things, which is what the code enforcement officer seems to be saying when I read their determination. They're saying there's a convenience mart and there's a gasoline filling station. The gasoline filling station isn't allowed, the convenience mart. Why is that?
Well, a couple of points. One, you are a quasi judicial board.
Sure.
Right, so when you say you're not a court, you're also not a
I
court
just
of
mean we don't
public.
have the laws of procedure, it's not an adversarial process, I mean,
Sure.
there's all sorts of ways it's.
Right, but it's also not a court of the public's opinion. It's a court of applying the code.
Right,
So to your question, there was never a determination made prior to the switch in January that we were not a convenience market.
okay,
And there's nothing that says we cannot fit within the two definitions, and when we fit within one, we're allowed to proceed under that because we have those property rights. So whether there was or was not a determination made that we were a gasoline and filling station use is immaterial to the fact that we are a
so
convenience
you're
market.
not,
So
you're not
what
saying that you're not a
know,
gasoline.
I don't want to be adversarial, but I do want to finish my
Yeah,
thoughts.
sure,
So the question before you is not for you to determine whether we're a gasoline filling station, but whether we are a convenience, whether the convenience market is a permitted use. So I
okay,
think
but
you want to
can
go,
there be two uses on the same, as part of the same project?
well, I think it's a little different. It's a question is, can a use fit within two definitions?
Well, I see that that's the point you're making, but I'm asking a different question.
Mhm.
It's like, if a project comes to us, I mean, it happens all the time, right? You have a project that says, hey, we're gonna have a restaurant and we're gonna have a retail establishment. In fact, the last applicant just mentioned Mill and Main,
Right.
which has a restaurant and it has, it's not in our town, but I'm sure that we could all agree that that's two uses
Yeah.
as part of the same project,
Yep.
right? So why couldn't a project such as this actually be two separate uses as part of one
Sure,
project?
because that's not what your code says. Your code says we fit the definition of a convenience market. We're not proposing a convenience market and a dry cleaner, which would be two uses. We're proposing a convenience market. So you can argue it also
Yeah, but
fits the
that's-
definition of a gasoline and filling station, but it fits the definition of a convenience market.
But you acknowledge that a project can have two uses. You're just saying this isn't two. uses.
Correct.
Okay. I mean, I can keep going with questions.
Here's what we're gonna do.
Yeah.
We're gonna hold off on taking that path for now. I think what we're going to do at this point is, because there's so many intricate questions that need to be answered for us before we can properly ask you and evaluate what your needs are, I think it's best that we go ahead. Let's go ahead like you suggested. I agree. We're gonna schedule a public hearing. We're gonna schedule for next month, if that's okay with the board at this point. That way it keeps the application on track timeline wise, because we're it's very important that the board maintain that timeline. I think that's our best course of action. If anybody has anything to discuss.
One
about
quick
that.
question.
Yes.
Procedurally, do you have, I mean, it seems to me this is a question of law, basically.
Yes,
And so I don't expect that you'd be calling any witnesses, but I just want to make sure when we get into scheduling.
I think part of that depends upon questions from the board and any comments from the public and whether the code enforcement officer intends to make any statements or testimony, but I would agree with you, it's a question of law, and I don't anticipate bringing any witnesses.
And I have another, this is just another procedural, I don't know, I'm not a lawyer like you, but, or you.
Right.
But another question of law, so my understanding of our town law is that any application that has not reached the point of a public hearing. If you reach the point of a public hearing and the law changes, your application is considered under the law that existed.
Well, there's a lot of nuances,
public
but
hearing.
that's not a question before this board or
No,
appropriate.
no, I know, I just wanted
So
to
I'm happy
like,
to have it when we close this meeting and discuss with you offline, but not as.
you don't
part of
even
the
want to talk
record.
about it. Okay, well,
No, I
I
just
just
don't think it's appropriate.
finish the thought. No, I agree. We can move this forward. I just wanted to like notice out loud that if the law changes, like if the town board has their public hearing next week,
Before the public hearing.
they, not even our public hearing, a public hearing that would go in front of the planning board, right? Like,
Yeah.
he's correct that our question doesn't, it's not relevant to what we have to do right here, and I agree that we should schedule the public hearing. But I just want to point out, maybe this is more for the public and also just for this board to be aware of, and I think it actually furthers your argument that we should move this forward and not delay it, like I agree. But if the town board next week has their public hearing, closes it, votes, adopts the new law, this entire question becomes moot.
Well, let me
I
just.
mean, we can still make.
No, it's
Sam,
still-
Sam,
no,
let me
it'd
just
still be a
pause-
matter
let me
of
just
record.
pause you there.
Not wrong.
We're not gonna decide whether or not it's wrong or not. I
That's
respect that council may have a different opinion
Yeah.
as to that, but we know that he knows, and he's quite
He's aware
aware
of
of the
that.
provisions
Right,
of
right.
140-1,
Yeah,
I believe, on the jurisdiction,
Yes,
and
right, right.
so,
Right. Okay.
we'll take it from there, but you're not gonna be surprised going
You're aware
forward
of that.
on the fact that, you know, there is a law pending.
No, we are now aware of that. I'd be disappointed, but not surprised.
Right, okay, so we're all good on that.
Yes, and again, I don't think it's an appropriate conversation with this board, but I,
Yeah, fair.
Absolutely.
The-
So
yeah.
I think that's where we're at. If everybody's in agreement, make a motion that we schedule a public hearing for next month, which will be when? Does anybody know?
March 20th.
Yeah,
Yeah.
March 20th. Right, March 20th.
Yes.
If I have a second,
I'll second.
in favor,
Aye.
any opposed?
I'm gonna oppose because I don't have enough information on it. And I'd like to have information with the council before I vote on anything.
I would fully anticipate us having proper representation before we get to the point where we have our next meeting, which at that time we'll be able to collectively address our issues and concerns through that attorney, Charlie. So that's kind of the tact we're taking with it, I believe.
Yeah, and we could have a conversation, we could have an attorney meeting before we had the
That's
public
correct.
meeting, so we
That's
could.
correct.
Yeah.
I
And
think
then we could even ask further questions to the applicant before. the-
my concern is the applicant's delay. It's the numbers exist, the days and the limits exist for a reason. And the last thing we want is for them, not so much the attorney, but the applicant themselves to be paying for attorney fees to be here. They could end up,
Well, it sounded also like,
I don't know what you charge an hour, but
I appreciate the concern. I share the same concern.
Finance has nothing to do with it.
I know.
We can't
also sounds
think
like-
about what is it a cost of money or if it's not at a cost of. money.
Yes, and the meeting will end up being at 6:30 too.
it also sounds like you've had
We
some
can report on
delays,
that.
not with the boarding.
Correct.
Glad to be an expeditious board when possible.
I appreciate that. Thank you.
So,
You just need your vote.
Anything further you need from us?
No, but I would offer that when you do retain counsel, I agree with the sentiment of the board. to the extent we can get you the information in advance, to the extent your counsel has questions, I would encourage him to reach out to him or her to reach out to me. Happy to have that conversation. And if there's any information you think of now that we should provide, happy to bring that to you, because I believe we reach the best decision when you have all the information, you have
100%.
questions. I appreciate that. Thank you.
So at this point, I think we'll close this application until the public hearing. That's where we stand.
We don't close the application.
Well, no, you don't even postpone the application. Don't not discuss the application anymore.
Yeah.
Yeah. Appreciate you coming out.
Thank you. I apologize, maybe I'm being too formal, but I didn't hear a vote that all said.
Yes.
Yeah, it was in favor, yes.
Yeah, thank you.
Three of them.
Yeah, no,
Yeah.
3-1.
I'm sorry, yeah, it was 3-1.
thank you. Appreciate that.
So the public hearing will be next
March
month on the
20th,
20th,
6:30.
6:30.
Hopefully no snow.
Yeah, let's hope.
March 20th, hopefully.
Yeah.
Thank you. I appreciate your
Yeah,
questions.
thanks. Yeah.
Take care. Thank you for coming.
Drive safely, please.
Will do. See you next month. Yes.
I hope so. Hope so. Before we close the meeting, though, there are a couple procedural things we need to address. I just, with regards to any application in the future, I think it's important that unless we're 100% sure, it's important not to engage maybe so much so that until we have counsel. Only because I'd hate to see a negative impact for the applicant. The other thing I wanted to talk about is changing our meeting times. It's kind of new business. Changing our meeting times to better fit our schedules. It seems that it's come to my attention that several members would benefit greatly by moving the meetings from 6 o'clock to 6:30. If that's okay, if anybody has any discussion on it. Free, if not, I'll make a motion to move them to 6:30 from 6 o'clock on a regular basis.
I'll second it.
So we, just to be clear, so we're saying
Discussion.
the standard meeting time
Will be 6:30.
6:30 for
6:30.
all, so the motion is to amend our calendar.
Yes, to amend the calendar, yes.
Yeah. I have no problem with that.
So,
It's already on the town website that way.
yeah, exactly.
You don't
So,
have to
see,
say
we're
that.
saving
How's
that. So everybody in favor?
But even, board member Coleman said that way all the meetings would be at 6:30.
Oh, at 6:30, that's a little easier
Yes.
mentally.
Yeah.
yeah.
just Planning board, and town board, they're all at 6:30
Great.
and whatever other meetings they got.
Thank you.
Take care.
Thanks. Supportive of that.
And the other thing is, I really hope you stay on the board, but if by chance, listen, if you by chance.
And the live stream.
No,
or-
no, this,
That was-
this,
No, we
I
have
want
to
the
keep it
public,
going. We have to keep it going.
I want the public to hear this anyway. Regardless of your decision, man, I'm glad you're here.
Yes.
I appreciate you doing this.
Oh,
I mean
thank you.
that a lot. I mean that a lot. People don't realize the work that goes in outside of the meeting.
Yeah.
If people could realize the phone calls that people like Ken this week took care of, they would see what we actually have to
Yeah,
do in
yeah.
the background. And now that I've sat here, I know what you were doing in the background, and I really appreciate that.
Well, thank you for saying that.
I mean that, and it means a lot.
We
You did a
all
lot.
appreciate it.
Oh, thanks, Charlie.
You did a lot. So while I'm not saying goodbye, I'm more encouraging you to
Stay.
retain your position
Wait a minute,
and
get the vote, yep.
and stay here because
You
your
don't get to
knowledge,
vote, we vote.
All
You
right,
here.
that's how.
you have a lot of knowledge that's here.
Oh, thank you guys.
And with these new zoning codes coming on, that knowledge can be shared.
Yeah,
The other thing I want to bring up, enough about you.
okay.
Is I do want to go forward with the name placards for people that are at the application table that know who they're talking to.
Right.
So I held off on doing a lot of this stuff until the town board decided to appoint me chair before we went forward and, we don't have to vote on this. This is strictly, hey, is everybody okay with this? Does anybody have a reason why they wouldn't want the name placards there? And
Well, we could just turn it around.
well, now here's the thing. If we're gonna have them, they have to be able to be seen. All right.
I want
We
to
can't put Bozo the Clown on it or,
I think it's a nice professional thing,
Yeah.
I do.
And I like how humble we are in like, you know, this. community
Absolutely,
group,
so do
But I
I.
think it's nice to lend a little bit of air of formality.
I mean, I think it speaks volumes when people know who they're talking to.
And the ones that's online, look at it, they see, oh, okay, now I know who's talking and stuff.
Sure, yeah.
Even if they hear, you know, like. Some of us,
Mhm.
if we're like, we're turned towards,
At least you know who
Play.
you're addressing.
and the
Yeah.
camera's behind us, they know, still know who it is talking.
What you thinking, Ken?
No, I'm okay with that. Yeah, I think that's fine, fine. I was thinking about whether or not I have any name placards at home.
I've got one, but it's not gonna be
Probably have.
appropriate for here. because It's
Okay,
got old titles and stuff on it, so.
All my jobs, I never have to have one of them.
And then what's going on? So Mary Lou had to recuse from
Mary-
this one.
Mary Lou had to recuse herself.
What about the,
Here's where we're going next. Now that we've gotten those silly formalities, I was hoping to get closer to 7:30 because that's kind of the schedule. I think that was set up to potentially meet with the one attorney, if at all possible.
tonight?
Tonight, yes. I don't know if anybody else was able to confirm whether or not they could make it to talk with the board before we decide who we want to recommend to Supervisor Noen for
Didn't know
appointment.
anything about it.
It was, this
I
was,
knew,
Charlie, I'm gonna tell you, this whole thing got thrown together by Ken and
well, I knew.
no, I mean, he handled this whole thing inside of 72 hours. He,
Yeah, well, I knew that you
Did
could
a
find
great
out
job.
if Mary Lou,
that
was
was,
excusing herself, but then she walks in tonight, and that's when I said, well, I guess she didn't have to.
no, she had to recuse herself from the gas line application, but she could still represent us in behalf of the board for the Basnet application.
Yeah.
And what do you have, what did you find out for that? If anything? Otherwise, we may end up have to collectively meet as a board to do
Mhm.
this. And I know that's difficult sometimes, but when, long and short of it is, we have to have representation, and the last thing we want is not to collectively make that decision.
Yeah,
That's my concern.
did you find any?
my last conversation with Miss Torre, Ashley Torre.
Yeah.
Do you want
was-
to go into executive session or do you
No.
want to? Okay.
Not yet.
So I'm not sure what you guys are.
No. We will, if we end up getting any interviews by the applicants, we can still address who would be applying.
Okay,
She was amenable to speaking with us this evening, and the question was with respect to the time. And we had mentioned 7:30, and earlier, before I came here, I was realizing that we hadn't actually nailed down the where-tos and the hows that we were gonna speak. So I asked her if she would send me by email, if she would send me a cell phone so that I could let her know if we would be ready earlier than 7:30. And I'm looking, I don't have a response yet.
So she's coming at 7.
No, she's not coming.
Oh.
She would not be coming in person. I
Do we
not
have
think.
any at all contact?
She was gonna be on the phone and you'd have it on speaker.
Yeah, that's what I
Yeah.
thought, or we could do a Zoom call, you know. or-
Whatever the case may be, so that
But-
at least we have an opportunity to ask some questions.
Can I make a motion that we adjourn temporarily so I can make a phone call and reach out and
Yeah,
perhaps
well,
see?
technically, we can go into executive session. We make a motion to go into executive session to allow you to make phone calls to contact the person. And then you can make another motion to end executive
Yeah, I don't
session.
know all those technical
Yeah.
rules, but I think that's fine.
All right, I make a motion to go into executive session temporarily to address our current need for
Legal
legal representation.
Okay, I'll second that.
All in favor?
Aye.
Aye. Any opposed?
No.
Discussion?
Okay, so now we gotta end this.
Yes, and now we can end this.
All right,
should I
so,
just end the
you'll
whole
call.
thing? or-
No, just postpone and make sure that it's completely paused.
I apologize.